I don't know if he wants to speak to the court or not, because I'll tell you, I'm leaning towards sending you to prison. No, I mean, why shouldn't I give you, like, why should I go along with 5 years prison? Why shouldn't I give you 20 or 15?
And that's not your job, ma'am. That's
I'm
his
just
job.
asking, I just like to have the information.
I get that, but we are raising trifling men. We're doing so much for them that we're not raising men. We're raising little boys that you and his mama are coddling him.
This is your 10th DWI. It's not your 5th. It's not your 8th. It's the 10th. 9 times over. Being given opportunities. I just can't do it. Going to sentence you to a term of 18 years in the institutional division of the Texas Department of Corrections.
Us here today.
Your Honor, I can appreciate you saying that loudly.
That's the error.
To say that there's one error doesn't mean that there can't.
You can leave my courtroom. Don't talk about me saying anything loudly. The reason why I gotta say it loudly, because I said it 7 times.
Give you credit for any time served. There's to be no contact with Eric Fields and Lefty's Draft House. I have parties announced for the record for the state.
Lindsay Shop for the state.
Defense.
Rainy Friday.
And are you Mr. Gutierrez?
Yes, ma'am.
Counsel, have you received all the discovery in this case and did you review it with your client? Court will find that the state is in compliance with discovery. Did you understand the state is proceeding on the lesser included offense of deadly conduct firearm is 3rd-degree felony? The range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? All right, after reviewing state's exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. We will come back on June 15th. At that time, I'll make a decision on your application. It'll be based upon the PSI report I receive and any other evidence that's presented. Do you understand? All right, thank you.
Your Honor, he's come partial expressed and in compliance. This confer with the state, they don't oppose the tracking only. What would allow it's because he has a child that he helps to care for and pick up and stuff. So,
All right, it'd be best if you take that up to with Judge Nahara. He's in 379 because we're about to start a jury trial. All right, thank you.
just if I may, I have a couple of paycheck stubs or 3 paycheck stubs of my clients that I'd like to offer. And I had given the state an opportunity to review them. And then I have some photographs of my client with his daughter, if I may offer those to the court for your consideration.
Yes.
Judge states on.
All right.
I also have a letter from his boss, Judge. I need to find that.
Okay.
His boss, Judge. I
All
have
right.
read-
If there's no objection from the state, if you want to make a proffer what the letter says, I do believe he's employed.
Yes, Your Honor.
You can look at this. It's a
It
matter of
just,
public
it
record.
speaks to his, promptness as an employee, as a valuable employee, and as to him being consistently employed and being able to continue to be employed should the court grant this application. This speaks to how much the employer values him as an employee, Judge.
Okay. All right. Is there anything else?
Mr. Gutierrez, on his behalf, Judge, has had a lot of time to reflect during the pendency of this case. He has 3 children, including a daughter whose picture I showed you, his biological daughter. And he has recently reconnected with her and reestablished good communication with her mom and with her. And he feels extremely motivated now between the opportunity he has at work to do well and his relationship with his daughter being very positive. And he wants to be able to continue in that path and show the court that he can do better. I see the PSI recommends intensive outpatient. I think their focus is probably alcohol. And if the court were to deem any other conditions of free, he would absolutely comply with whatever conditions the court would deem appropriate. He has been on GPS for a considerable amount of time while this case was pending. I think maybe since
So it's been a year or 2 months.
a year and 2 months, he's been on GPS with no violations. And I think that speaks to his motivation to do better and his respect for the court orders and his ability to be a successful probationer. And I hope the court will take into account, that's a significant amount of time. He was on full GPS house arrest, and then that converted to partial where he's been able to work, but no violations. And so we're hoping the court will give him an opportunity to show the court that he can be successful on probation.
All right, but here's my concern and what I don't understand. How old are you?
37.
You're 37. I don't understand going to a bar and people tell you to leave. And your answer to people telling you to leave is, I'm going back to my vehicle and I'm getting a gun and firing the gun. I don't understand that. So I don't know if he wants to be under oath to explain that to the court, but this is what I'm trying to wrap my head around. I don't understand why people's first answer to any situation is, let me go get my gun. And I know people, I don't know, people seem to have a love affair with weapons. And if you want to have a love affair with the weapon, then you need to treat the weapon with respect, because the weapon can kill if it's in the wrong hands. And I'm just trying to figure out, there's an incident that happens. Somebody calls you out your name. Oh, let me go get my gun. I'll show you who I am. Somebody tells you to leave a bar because, I don't know, maybe you're intoxicated. Maybe there's some altercation. I don't understand why people don't leave.
I would say that the offense report and PSI reflect that he says he had 5 beers and 3 shots. So I would submit to the court that he was not thinking.
Yeah, I mean,
He
to
was-
me,
And I'm not saying that intoxication is a defense or mitigating at all. I'm just saying that, it causes a loss of impulse control. And
I mean, I understand what you're saying, counsel, but sometimes I think alcohol gives people courage to do what they otherwise wouldn't have done, as opposed to, oh, my inhibitions are released. Yeah. So I don't know if he wants to speak to the court or not, because I'll tell you, I'm leaning towards sending you to prison. I haven't heard anything that would suggest to me that I shouldn't send you to prison, because I don't know somebody who takes some shots. I realize you were intoxicated. I'm reading it, but people put you out of the bar. And it's on Mother's Day too.
It was 6 guys that took me out.
Yeah,
So
because you wouldn't leave. When people tell you to leave an establishment, just leave. So I don't understand why I should give him deferred adjudication when he went to a bar. And according to things he's saying, somebody tried to come on to his fiance. That's when you leave. And they told him to leave. And maybe they were very rough and pushing him out of the bar. I will give you that. They were rough. They bruise you up, maybe push you out of the bar. But that's where you leave and go home. Hopefully you were not driving with those tequila shots. And then, or if you don't want to leave and you stay in the parking lot, you call the police, but you don't tell people, well, I'm going to show you who I am. And then you go to your vehicle and get your gun. Did your fiance say any, did his fiance say, hey, what are you doing? This is crazy. Let's just go home.
I don't know if that's-
Okay.
The altercation at the bar wasn't good. I think that there were probably others there who also had weapons. Again, not to say that there's necessarily a defensive or mitigate, but maybe it's a little mitigating. It just turned out to be a very rough circumstance. I'm not making light of the offense because obviously it's serious. And I think that the PSI speaks to a the alcohol being an issue and intensive outpatient. So I think if the court would give him some opportunity to address the alcohol and maybe perhaps anger management issues, maybe that would help to lessen his future risk to the
And I see
community.
that there are other people who had guns because I see Eric Fields, who's one of the complainants, not the main complainant. He says, I just want my gun back.
Yeah.
This is Texas. We just want our gun back.
Right.
So ma'am, I haven't been in trouble since 2005. And being at that
You want to
bar,
raise your right hand to be sworn in? Can you, do you solemnly swear and affirm that the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, you can lower your hand, state your name for the record.
Guadalupe Gutierrez,
And let me just tell you, your statement about you haven't been in trouble since what time?
2005.
I haven't been in trouble since 1969, and I'm putting it at 1969 because I was potty trained by then. And I didn't pick up any criminal cases. I always tell people when they tell me I haven't been in a gang, I don't do drugs, I haven't been in trouble. It's like, do you want a cookie for that? That's what you're supposed to do. So let's not start with, I haven't been in trouble since this date, because I'm looking at your criminal history and one of them is terroristic threat. And then criminal trespass. And is this criminal trespass with a weapon?
That was with a box cutter at my aunt's bar. I just left work.
Okay. And then the theft of a vehicle.
That was back in 04.
And now we're back here.
Yes,
And on on the probation from 2013 on the criminal trespass with a weapon, your probation had to be extended. Then on the theft case, a motion to revoke was filed and you were sent to TDC. And now you have this that started as an aggravated assault with a deadly weapon, and the state reduced it to a deadly conduct 3rd degree. So speak to me. Why should I give you deferred? I don't understand why I should.
well, I mean, I'm not a good talker, but.
That's
you told
okay.
me not to say how it started, but
No,
I
go.
was trying to prove a point that since 2005, I haven't been in trouble. And all those years, I was in the oil field for 15 years and I've never had my daughter. So now that I got my daughter, it's a blessing to me because I always wanted it. So now I have an opportunity to be a father and I don't want to mess that up.
I mean, but you have.
I understand.
I think the reunification, if you will, sort of took place after this offense. Is that correct? Meanwhile, you've been on probation with your daughter.
Yeah, it's been good. It's just like I've been on the monitor and I can't blame nobody else but me. But it gets me kind of angry because I can't take my daughter out other than be with her in the living room.
Well, I don't know why you angry about that. That's all on you.
That's what I just said.
If you would not go to a bar drinking to the point of intoxication and you're in your 30s, you're not a teenager who doesn't know better.
I think that if the court would give him an opportunity for some form of treatment, I think he would welcome that and appreciate that opportunity.
I just don't think he's a good candidate for probation. I mean, shooting up a bar. And it wasn't.
It was outside in the
Mhm.
parking lot.
And State, I know you're silent.
Yes, Judge.
Is our applications for probation, for community supervision and deferred?
Yes.
Know if it makes a difference to the court. I don't think it necessarily does, but we can withdraw the deferred.
Now, see, this is what I'm reading, and this is my problem. I can understand people being angry and getting upset with people. I honestly don't ever understand people pulling a weapon, because I always taught if you're going to pull a gun on somebody, you need to know that to kill somebody, and don't pull a gun unless you're going to use it. That's what I was always taught. But what it says here in the police report that you stipulated to, I contacted Jason, who is the manager and point of contact for surveillance. Jason provided me with footage from one of the cameras. Jason said he was working on getting footage from the other cameras as well. The footage showed Guadalupe, that's you, being taken out of the bar. He walks to his car and pulls out a small handgun. Guadalupe pointed the gun in the air where 4 spent shell casings were found. Guadalupe and Melissa got into the vehicle and he pulls up to the curb. Eric can be seen in the corner near a white car. Guadalupe opens the car door and his hand extends out. Guadalupe then lowers his hand with the gun and points it toward Eric.
I never pointed the gun at
I mean,
anybody
that's what
else
they
but
say is on the
her.
video. I mean, this is video. This is not,
And I showed her that when I saw the video, I pointed it.
Well, because it's surveillance, some parts of it are a little clearer than others, but as the car drives out, it's a little bit less clear because of the angle of the camera.
okay. All right. Is there anything else from either side? All right. How old is your daughter?
7.
Okay. All right. This is what the court is going to do. The court is going to find you guilty, sentence you to 3 years in the prison, give you credit for any time served. There's to be no contact with Eric Fields and Lefty's Draft House. Showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
All right, because this is a plea bargain agreement, and because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes.
All right, good luck to you. I did take into consideration that you have a child and that you want to be in her life and do better, but you're going to have to start making better decisions. And it's obvious that you can't drink alcohol at all. So no alcohol, you understand? All right, good luck to you. Places.
Yes, ma'am.
Did you understand you're charged with the offense of aggravated robbery? That's a first-degree felony. The range of punishment is anywhere from 5 to 99 years in prison and up to a $10,000 fine.
Yes, ma'am.
In States Exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. The court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, I have visited with this young man and his family. I'm just hoping to put this past them and turn this negative into a positive situation. Just ask that the court would follow the plea agreement.
All right, why should I follow this plea?
He has to pay for his.
No, I mean, why shouldn't I give you, like, why should I go along with 5 years prison? Why shouldn't I give you 20 or 15? Basically, what has happened in this case is that you and your friends decided to try to take a vehicle that did not belong to you. Well, actually, you did take it. And you know how they identified you? With that silly Marbach haircut that everybody seems they want to do, which, as my mom would say, that's really the Larry Curly Moe haircut. I don't know why people think that that is the haircut to be, but that's how you were identified. So,
actually cut my hair. Long, black, and all the way down.
yeah. So, and that's all you take away from that. How far did you go in school?
Okay.
So you're in 11th grade and stealing someone's vehicle that doesn't belong to you. Where did you see this ending? Did you think at some point in time that car was not going to be found? All cars have locators in them now. So how did you see this playing out? You're in Texas. You're lucky somebody didn't shoot you. And then you know what would have happened when somebody would have shot you? Your mom would have been crying on television, asking for that person to be arrested. And then you know what the citizens would have been saying? Oh, well, he got what he deserved. And they would have just moved on to the next person. Don't be that person, although my mom has already told me this. You know what my mom tells me every day? She says, Stephanie, you and the people in your age group can never retire. And you know why she can't? She says we can never retire? Because she said, look what's coming behind you. And so what we have coming behind us are people who are going out instead of working to get what they want to go take a vehicle. Now you're going to end up spending 5 years of your life in prison. And was that vehicle worth that? 5 years of your life? Well, now that's what you're going to do. And you've made your life very difficult because now you're somebody who hasn't graduated from even high school and you're going to have a felony conviction. It's all you. Court is going to find you guilty, sentence you to 5 years in prison, give you credit for any time served, take in consideration 2023 CR 0281, 2023 CR 1479, County Court Cause number 697768. There's an affirmative finding of deadly weapon and there's to be no contact with Donovan Treadwell. Showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. You understand?
Yes, ma'am.
All right, we can go off the record. So young people, they think when they go to prison, it's the end of their life. You still have plenty of time to do great things on this planet. Me, I'm in the twilight of my life, but you have more time. So what you decide to do with your life is completely up to you. If you want to be in and out of prison, if you want to be the person at the prison, that's the oldest person at the prison, and people say, hey, how are things running here? And they say, go ask Grandpa Delgado. If you want that to be you, it can be. Otherwise, when you get out of prison with your felony conviction, you need to try to turn your life around. You understand?
Yes, ma'am.
All right, good luck to you.
Thank you, Your Honor.
You're welcome. Me too.
So, Your Honor, so what Mr. King wanted to share with the court was that he's been kind of proactive. So he said that he's completed some defensive driving courses, some anger management courses and things like that. But we understand that the court's main concern is the alcohol. So if there is perhaps any sort of monitoring that Mr. King can have while he's out of jail, or perhaps testing, he would be agreeable to something like that. But we just don't feel like him being in jail. I personally, I don't believe that he's going to be a danger. He's got the support of his grandmother who's here in court with us today. And like I said, he's gainfully employed and he does have a child and he does have a lot to lose, and he understands that, especially having
Well,
been in here.
Ms. Hahn, it's not necessarily that I think he's going to be a danger per se. The concern that I have is that he's gotten 2 subsequent charges, one of which definitely involves alcohol, since he got a DUI. And so all of these things coming into play, you can present all of this to me as the reason why I shouldn't put you in the jail, but none of that kept you from getting 2 subsequent charges after a DUI. I don't understand what's going on. Like, now I'm supposed to feel bad. Oh, he's got a 2-year-old. Well, that was your choice. Nobody told you go out there and you got pending charges and your life is probably not stable and you out here having babies. I'm not a proponent of just willy-nilly having children and then using them to try and play on the court's heartstrings, because I feel like children deserve the absolute best that we can give them. And when we just out here having them and then trying to figure it out on the back end, I'm not a proponent of that. And I see your grandmama sitting back there with her hands over her face, praying for you and everything. And I think that's a good thing. But I think that you need to take some personal responsibility. You're 25, you've chosen to have a child and become a parent. But you also have committed, allegedly, you have 3 different pending cases, not charges. You got 1, 2, 3, 4, 5, 6 pending charges before the court, and over the course of 2 years. And so I don't understand why I should now let you out again and risk you getting another charge. Because if you stay in jail, you'll come up next on the trial calendar. We can go ahead and try these cases and get them done. We can try them back to back to back.
So, well, one second, Your Honor.
Yes, ma'am.
If I could just say one last thing on behalf of Mr. King. Your Honor, obviously, we still would like for him to be released, but you know, I know that Your Honor is concerned about alcohol. Mr. King hasn't had any infractions involving alcohol or any issues with alcohol, at least since April of 2022. So it's going on almost 2 years.
August of 2022.
Well, I think the last case involving alcohol, Your Honor, was the one ending in 0297 is my understanding.
You go tell me he was stone cold sober when he went over there to the same person from the April incident? All right, I'm gonna let you have that one.
Thank you, Your Honor. But so, Your Honor, Mr. King and his grandmother was also kind of chiming in as well. Let me know that there aren't any concerns, at least we don't believe that there are any concerns that the court should have about alcohol. He's kind of been on the straight and narrow for over the last year. And so we would like the opportunity for him to get out of jail and kind of fight these charges from the outside. Because he does maintain with me that he's not guilty on all of the cases. And that's kind of what I was trying to explain to him as to why we won't go into the details of that here today as to what happened in each of those cases. But without doing that, he does want the court to release him.
All right. If I release him, he's gonna test every 2 weeks for substances. If he misses a test, he comes back to jail. If he tests positive, he comes back to jail.
That's fine, Your Honor.
All right, draw up the order.
Thank you.
He'll go to he'll make an appointment with the probation office and he'll test every 2 weeks. He misses if he misses a test, he's coming back to jail. If he tests positive, he's coming back to jail for any substance, alcohol or anything else.
Thank you, Your Honor.
All right. You can go back with the sheriff's office, Mr. King. Not to have any contact, no contact, not social media, not text message, phone, nothing with Frazier, K.N. Frazier. Any contact with her, he comes back to jail.
Thank you, Your Honor.
That's the baby mama, I take it.
Yes, Your Honor, that's correct.
Okay, no, still, because I'm assuming that he hasn't married this woman or legitimized that child.
Not to my knowledge, Your Honor.
We're gonna start doing stuff the right way. Until those things happen, he is not the legal parent of that child. If folk just want to come out here and just be having babies, that's on them. But understand the situation it puts you in when you don't have those things in place. And so, no, he's not to have any contact with the baby, not through the grandmother. The grandmother can't call her. No, y'all can't see the baby unless unless the Superior Court of Clayton County or the court where the baby resides decides that there's a visitation that has been set up due to a legitimation petition that has been filed. So this is the sacrifice you're gonna make. When we start doing things the right way, then we don't have these issues. But no contact with K.N. Frazier or the child of K.N. Frazier. No, Grandma, no. Come on up, ma'am. See, your grandson is in this situation because somebody's always taking up for him and he's not getting responsibility for the things he's doing.
I understand that, Your Honor, and thank you for allowing me to speak. But what we did, his mother and I, when they were having their spats, we only go pick up the baby now, or me or his mother.
And you shouldn't have to do that because they should be grown enough. If they're grown enough to have a baby, they should be grown enough to co-parent. But anytime the grandmama and the mama have to get involved in transporting the baby because they can't get along, that tells me that they're immature and shouldn't have had the baby in the first place. So he needs to grow up. And no, I'm not going to facilitate that. No, ma'am.
Well, actually, it was his idea.
I don't care.
Not to have the interaction.
I don't care. He had a baby with that woman. If he can't now co-parent with her, that tells me something about the fact that they shouldn't have even had a baby together. So no, y'all can't have any contact with her until such time as that baby is legitimized through the courts.
And what court do you do that?
Superior Court, and that's not your job, ma'am. That's
I'm
his
just
job.
asking, I just like to have the information.
I get that, but we are raising trifling men. We're doing so much for them that we're not raising men. We're raising little boys that some other woman is going to be burdened with taking care of. Even when if he gets back with Kay and Frazier, she going to have to do everything for him because you and his mama are coddling him. There was a time in this country where once you left your parents' house, you were responsible and you had to make your way and be responsible. Every successful person I know, including myself, you get from your parents instructions when you finish high school. Hey, I don't know what you're going to do. College, military, work, but you can't live here. And we are so busy coddling. I know he has a place now, but we're so busy coddling, especially young men. We seem to be wanting to raise women to be responsible. You got to go out and get a job. You got to do this. You got to do that. But parents continue to coddle these young men. And so they end up not being responsible for themselves or anybody else. He's a parent now, so he's grown. So anything that happens on his behalf or his child's behalf, he has to handle it. Y'all need to stop stepping in.
I respect what you just said, but in the case.
No buts.
He stepped in and is taking care of her daughter that is 4.
So
and my family and everybody that knows him respects him as a good father. So I cannot let it be said that he's not a good parent.
I didn't say he wasn't a good parent. I said they weren't mature enough to co-parent.
I recognize that, but I do want it to be on record that he is.
No, I didn't say he wasn't a good parent, and there is a path to him being able to parent his child. I told you what it is. But what I'm saying to you is you and his mama can't live his life for him. And as long as y'all are doing for him, then he won't be able to do for himself.
Thank you for that, Your Honor.
I'm just saying you recognize what I'm saying. When you left your parents' house, how old were you?
18.
And did they say you never went back, did you?
Never went back.
Okay, this man is 25, and I'm gonna tell you what my grandmother said. My grandmother raised 13 children, and you know what she said? She said, I have never had to stand bond for any of them. But you know what she also said? If you do something, don't call me. She's right. I raised you to be responsible. I raised you to do the things that you should know how to do. And so of her 13 children, none of them had to stand in a courtroom or call come get them or call my grandfather to come get them because I've raised you. So now you're on your own to be responsible the way I taught you to be. And we have gotten so far away from that. We got kids now telling their parents off, taking their parents' vehicles, hitting and interacting with their parents in such negative ways. But at a minimum, we're not raising children to be responsible. At 18, your parents said, that's it. And you went out and you made your way. And you look reasonably successful. Now, I don't know you, but you don't look like you're struggling. And what I'm telling you is until you let somebody get out there and do what they need to do, and you're looking at me in this role, but I'm gonna tell you right now, when I went to college, my parents was like, okay, you made it into college. All those student loans, I had to pay. When I went to law school, I had to pay. I was working 2 jobs in college and going to school, 2 jobs and going to school. There have been other times in my life when I worked 2 jobs and gone to school. So what I'm saying to you is he can do if y'all step out of the way and make him do it. But don't keep coddling him and we gonna facilitate seeing the baby and we gonna make sure because y'all can't co-parent because y'all fighting each other that we gonna make it easy to go back and forth. Go to court. He can go to court, set up a visitation schedule and get a Superior Court judge to determine how this is gonna happen. But in all things, he's going to be a parent for the rest of his life. So if he can't get it right now at the beginning, when it's easy, it's not going to get any easier. It's not.
And with all due respect, Your Honor, I don't condone. I didn't help you get into a mess. I can't help you get out, but I do support helping you through it. That's the way I look at it with my kids and my grandkids.
I got you. But what I'm saying to you is, remember how you made it. And people think it's harsh. But when your parents said, you 18 now, you on your own, you might have struggled. But right now, if you face with any situation in your life, you're going to figure out how to get it, how to make it work.
Yeah.
Because you've had that experience. We don't let our kids struggle. So when they get out there, the first thing they're going to do is turn back to mama. What am I going to do now? Well, if you struggled when you first got out there and made your way and realized you got to work, you got to pay bills, you got to find a place to stay, you got to maintain a place to stay. When you do those things, it makes you responsible and able to handle whatever challenge comes your way. But as long as the parents are stepping in and keeping these 20-something, I even give a little grace for the 20s, but the 30s, the 40s, you know, I got parents who carrying these people on their back, and they're coming in and raising discord in their households. We have got to stop coddling these young men. He went out there, he had a baby. So if he's chosen to give up his 20s and his carefree lifestyle to be a parent, then he's got to do what it takes to do it right. And if that means going to court and legitimizing his child, getting the money up to do what he needs to do, then he needs to do that. But nobody's telling him to go out here and just have babies without thinking about the consequences of what that means.
So is the birth certificate not legitimate?
No, ma'am. I can't tell you because I don't do that kind of law. But what I can tell you is generally, no, you don't sign in the birth certificate does not legitimize a child. It may be biologically acknowledged as his child, but under the law, no, not until they were married at the time of the child's birth or within a certain period of time after the child's birth, or they go through the legitimation process in the superior court where the child resides.
Okay.
So I'm just saying, and I understand you and mama want to help him and y'all want to see the baby. Y'all might have to take some time, but y'all can't contact this woman on his behalf.
So we missed Christmas. I still have her stuff.
Okay, the baby will get it. The baby don't know it's Christmas. It's 2-year old. She'll get it when she gets it.
Thank you.
All right.
State of Texas versus Catherine Welch. Ma'am, are you Catherine Welch? Yes, Your Honor. And Ms. Welch is here with her attorney, Mr. Gertz. State's attorney is present. Ms. Welch was previously in court, entered a plea of guilty to driving while intoxicated third or more, as well as a prior offense, which made it a second-degree felony offense. There was no agreement with regard to punishment. I have received the pre-sentence report. And has everyone had an opportunity to review that report?
We have, Judge.
Are there any additions or corrections to that report?
Not from the state, other than I want to acknowledge I have received Mr. Gertz's sentencing memorandum.
I'm going to get to that too in just a second. Any additions or corrections?
Aside from the one comment that I make in the sentencing memoranda about a comment that she made about rehabilitation, I think it's more of a clarification, so I'm happy to touch on that. But other than that, we don't have any additions or corrections.
Okay. And Ms. Malfino has already stated, as well as I have received the sentencing memorandum at 5:47 p.m. yesterday. Going to point that out for the record.
The Harris County judge got her sentencing memoranda at midnight, so.
Well, it was reviewed quite early this morning, but I did review it. Ms. Malfino, you've had time to review it as well?
Same here.
Okay. Other than that, I think you all should have a couple, there's only a few, but there were some jail incident reports that should have been provided to council. Did you both receive those as well?
Yes, Judge.
I did.
Okay, is everyone ready to proceed with sentencing then?
Yes, Judge.
Yes.
All right, Mr. Gertz, do you have witnesses?
I'm not going to call any live witnesses unless the court requires it. When we have a person present from the Dream Center, if the court wants to inquire about that, I would essentially let her come up and talk if you want to have that conversation. But
Okay.
I think, our focus here is going to be on the topics that we talk about or write about in the sentencing memo. And, just sort of allowing, if the court decides to do what we're asking you to do, we are open and welcome to whatever the court requires of her
Sure.
to enter and successfully complete. We just wanted you to have that option on the table as well. That,
Okay.
yes, an option that doesn't cost the court anything. Or the
Right.
state anything.
And for the record, I'm aware of the Dream Center and their program and what they do. And so if I have any specific questions, if we get to something where I would need that, then I appreciate them being here and I'll ask those questions. Ms. Malfino, does the state have any witnesses?
No.
All right, then argument.
Judge, I want to, I recognize this is a unique case and a unique ask that we're making here. This is not something small that we're asking for. I have sort of personally taken Catherine on over the last 3+ years, I guess almost 4 years, as a project for me, if that makes any sense. And what I mean by that is I really wanted to put to the test, could this person do everything that I asked her to do to at least get her an opportunity to be here in front of you asking what we're asking for? She exceeded my expectations by doing the 90-day inpatient rehabilitation. And while she was there, she started to explore with her counselors and her therapists there some of the underlying issues that went beyond just physical addiction, but actually had to do with her mental health and some of the things that she's experienced in her life. I'm not going to detail them on the record, but the court is aware of what those things are. Incredibly traumatic events that I think she had repressed and had never really addressed and explored. And so those counselors recommended not just aftercare, but a specific outpatient program to address some of the trauma issues that she's had. She went and checked into that program, stayed for basically a year, and again, did everything we asked her to do. When I told her to go get her own drug patch, I told her to go get her own interlock device. She did all of that. Those records should be attached to the memo. She was successful, has been following the rules, doing everything we've asked her to do, had been going to AA, had gotten a counselor, actually reached out and befriended the director of the Dream Center to try to figure out what she can do next to sort of commit herself to her sobriety and to fixing the mental health issues that I think stem from the challenges that she faced as a young person. Sometimes it's easy to look at one side of the ledger, the rap sheet or the criminal history, and think that defines this person. What I have been fortunate enough to do is to really dig down and get to understand her as a human, and see that all the progress she's made, all the effort she's made, and see what she's done well and all of the problems that she's been addressing well. She's obviously very anxious about this day, but we've been looking forward to this day as well to be able to present that. And I want to go down on the bottom of page 2, address what I was talking about in the CSI. So that I'm not saying that this wasn't the words that came out of her mouth, but when she was asked by one of the examiners in the probation report if she felt she needed treatment, she said she didn't feel like she needed treatment. She wasn't opposed either. I want to clarify what we mean by that. And I say this here, but what she would say, I think, is she did 90 days of detox rehab related treatment, has continued aftercare, has continued mental health care. But in terms of going to a program that is specifically targeted at people who are currently using or currently intoxicated, I think she thought that wasn't the direction that would be ideal. She will do whatever you want her to do, but I wanted to explain what that comment means. And so, because a lot of times, as you know, Judge, private rehabilitation programs will just reject you if you've been clean for 3+ years, as she has. And so they just won't even accept you at all. So I think that was just a misunderstanding or a miscommunication between the probation officer and Catherine. But nonetheless, she's willing to do whatever the court chooses here. Additionally, we've been in contact with her current parole officer. They are willing to keep her on parole instead of revoking her, depending on what the court does here. And so that was encouraging as well. I think we had the same kinds of conversations with them about her recovery and about her efforts. And so I think that was an encouraging sign from them. And then finally, Judge, you see, we didn't want to focus too much on support from the community because, again, this isn't just a run-of-the-mill case. This is a different focus. But she is married. She has a family. She recognizes the impact that all of this has had on her family and her relationships, the strain it has put on her husband, both financially and also emotionally. And she accepts responsibility for that and is asking the court to consider this extremely rare position that we're asking the court to take here. Obviously, if the court would like her to address the court, she is happy to do that, or I'm not sure how you want to proceed on that.
Okay, thank you. Ms. Malfino?
Judge, I don't envy the position that the court is in this morning. I do take very seriously the comments of Mr. Gertz. I take him at his word for that, and I hope that all of those things are true. It's difficult for me as a representative of Jefferson County and the state and the citizens that are on the roads every day to stand up and say I agree with probation, but I don't disagree with the things that Mr. Gertz has said and the information that is in his sentencing memo. To play the other side of the coin, does it suggest that she received the benefit of the doubt already by me waiving the habitual status that she could have been facing based on her number of priors? Does it seem in good conscience that I can say I ignore all of those priors? Absolutely not. But obviously, we have seen that her multiple trips to the penitentiary have resulted in no change of behavior until hopefully now in these last 3 years. And I do sympathize with Ms. Welch as an individual. Again, it's hard for me as a district attorney, assistant district attorney, to say that I concur with the punishment being probation, but I don't, again, disagree with the comments that Mr. Gertz has. We've had multiple conversations about this case. I know he's worked very diligently at it. I don't really know, Judge, and that's why it's before you, that putting her in prison for 20 years and her getting out in 2 versus an extensive probation period where she can continue the recovery she's been doing is a better option. But again, I don't know what is in the best interest of public safety. Unfortunately, none of us do. So I would defer to the court's wisdom and whatever you think is appropriate based on the volume of information.
All right, thank you. Anything else?
You like to say something, Judge?
Your Honor, I just want to say that the past was fueled by drugs and alcohol. I take complete responsibility for that. I did not know from very young when things happened in my life that it could have been, some of it could have been treated and stopped earlier if I had gotten help for my mental health. That after I received this DWI, that helped me get myself to a place that I could go into a treatment program and deal with some of those past traumas. In the past, I didn't. I medicated and drank to just forget about the pain, just numb myself out. I didn't know how else to deal with that until when I got on my mental health meds, and I have bipolar, I have PTSD, and my mind back then was very chaotic. And I just want to say, after I had my mental health meds, I was able to go through treatment at Santa Maria in Houston, and that place really saved my life. I did extensive 90-day treatment with trauma counselors. It was a trauma-informed community there. And also, when I completed that, I worked an outpatient program, but I still lived on their facility I went to the sex trafficking and recovery program, and I was in that for about 8 months, where I got the state paid for the counseling for trauma still. And I just worked really hard in that. I got a job while I was in there. And then once that program was over, I moved to a sober living facility in Oxford House in spring, and I worked there until I felt like I was strong enough to come home and do what I needed to do. And I was in the complete program for right at a year. And I'm sorry, I'm very nervous today. And I know that my past record is, like Brian said, atrocious. But you know, the things that I had to deal with within myself from when I was a little girl, those are things that you don't go to prison, even in their programs there, that you don't talk about. It's just, you just don't. And I'm asking you, please do not send me back to prison. I want to move forward. I have moved forward in my life, and this year that I've been in jail has given me more time to think and know that I am definitely headed in the right direction. I have a sponsor. I attend AA at home. I had moved on with my life as far as I could with my sobriety. I mean, I knew this charge was out there. And I think I made some really good choices with my Mid-County AA friends. They've helped me a lot. And I am open to anything. I will abide by all the rules and do anything that's asked of me. And I think, I know now that I'm responsible and capable of taking care of my business and my life.
Thank you. So, Ms. Welch, Ms. Malfino probably said it yet best, and I get this often, and they don't envy my position, and this is the worst part of my job. But I worked hard to get here, and it's my job. Part of my job, it's several things, and it's to look at, obviously defendants and giving chances and things like that, but it also is about making our community safe. And I have to look back. This is your 10th DWI. It's not your 5th. It's not your 8th. It's the 10th. And while I understand the trauma that you went through, that you've been to Safe P 3 times, you've been given opportunities on probation where they were revoked. You've had opportunities while you were on parole to do what you have done now. And while I appreciate what you've done, and I think that's great, and my goal isn't to to stop any improvement, but I can't, in my opinion, in good faith, go home tonight, look myself in the mirror and say I gave somebody on their 10th DWI that your last sentence was for 15 years in prison. The one before that was for 10. The one before that, you've gone to another 10 year back in 09. I mean, this goes back to the 90s. You got a 10-year sentence in 2011. While you're on parole for that one, you get another one. So they give you 15 years and you get out and you're on parole and you do it again. The fact is, we're just lucky that you haven't killed someone in our community 9 times over, being given opportunities. I just can't do it. I'm going to find that you entered your plea of guilty freely and voluntarily. I'm going to find and your plea of true to the prior offense. I'm going to find sufficient evidence to find you guilty, and at this time find you guilty of driving while intoxicated. I'm going to sentence you to a term of 18 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. You're going to be handed a trial court certification that shows this was not, well, I guess there was an agreement because the waiver of the enhancement, which could have been a 25 to life, as Mr. Gertz said. So I'm going to hand you the certification that shows this was an agreement. You've waived your right to appeal. I'm also handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Possession, because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. You should read the written admonishment I provide you. If you have any questions about that, you can talk to Mr. Gertz. And Ms. Welch, I take no pleasure in this. This is extremely difficult for me. I understand to some extent addiction, and I understand that you are on a better path. However, there have been plenty of opportunities in the past where you were on a better path and you got back out and you got back on our roads again. And so good luck to you, ma'am. Thank you, Mr. Gertz and Ms. Malfino. Court will be adjourned.
Yes.
Just a quick clarification on the Shakita Burgard matter. That matter was actually inadvertently dismissed about a month and a half ago, and that's the one where we had that brief exchange where it was mistakenly dismissed. We put it on record, and then the court ordered a default judgment. I think the clerks accidentally put it back on calendar, and I found out after I was here for a separate matter that they logged it into too. So they took something that the court on the record said default judgment. We're waiting for a judgment about 3 weeks, 2.5 weeks.
Did you submit a default judgment?
No, and that informs the second issue that I have here. And the reason I have is, long story short, is in the court knows, so I'm not going to take a lot of time, but just very briefly, if a counsel's on a tenancy matter, then any action that's filed has to be e-filed. And
Well, couple issues here.
Sure.
You never filed an appearance on it.
Sure.
So when I'm looking for a plaintiff 30 minutes after the case was supposed to be called,
Sure.
and there's no name for it, who am I supposed to, how am I supposed to know who is
No, I'm with you.
on there?
No,
So
I'm with you.
I don't know what the clerk's office may or may not have done. I have no idea. All I know is that this was on my docket for today for
Sure.
2 o'clock. The defendant was sitting here, and after 30 minutes, we dismissed the case.
Sure, I know, but that was 3 weeks after the court already ordered a default judgment when I was here on that same case.
I recognize that, but
Right.
when you don't file it 3 weeks ago, you didn't file a default.
Sure. Yeah, but not filing a default doesn't validate the ability for the court. It doesn't.
If you had filed a default, the case would have been closed.
Sure, but
When that, and we have attorneys that never file their defaults or never file their dismissals, and they leave it on me, then I have to go back in there and either set it for another hearing or enter the dismissal. And so this probably, and I don't have the case open, was not an issue of the clerk's office making an error. What they do when the default was supposed to be entered and it does not get entered by the plaintiff, they ask me if I want to just dismiss the case or set it for another hearing. And that's probably why this got reset for another hearing. That was not a mistake. You never filed, the mistake was you never filed the default.
And I can appreciate the court saying that that's something that can happen. When the court says probably more likely than not, the reason that I'm a little bit resistant to that is that while we were here, we've had a pattern within the history of the same case where it was dismissed before wrongfully, accidentally, inadvertently, and we have back and forth exchange. But with all that said, the reason I didn't file
Put the
anything.
case back in here so I can pull it up. What
I
case is
appreciate
it? This is,
I have the docket in here.
it's Shakita Bogard, 25-00871.
It's a 1L2. And so the reason that I didn't file it is that if I would have filed an appearance, it would have precluded my client from doing all the paperwork. So initially, I was just going to come here limited appearance. I know that's subjective outside the scope of what the court does. I'm just saying.
We know good and well that if the attorney is representing, they're supposed to file an appearance.
Sure.
How are we supposed to know who's appearing on behalf of an attorney if you don't file an
Sure,
appearance?
but not knowing who appears is different than a case that should have been on the record.
No one-
Said it might have
No one was, no, the issue was you didn't file a default.
No, but that's what I'm saying, Your Honor.
Yeah, the
reason-
issue, I don't see I didn't follow default, Your Honor.
Your Honor, you're talking about something different that I'm trying to.
Had you
address
filed the
here.
default, we wouldn't be here today.
Your Honor, and there's clouds in the sky too, but what I'm saying.
No,
is
there's
something
no clouds in
completely
the sky. Had you filed a default, we would not be here on the docket today.
Your Honor, I could say the same thing over and over, but that's not what I'm saying. I'm saying something completely different. And if the court will hear it out, what I'm saying is before, if we go by, if something shouldn't have happened or would have happened the way that it was supposed to, we wouldn't have been here.
Why are we talking then? What?
No, the point is.
No, you were supposed to file an appearance, you didn't do it. You were supposed to enter a default, you didn't do it. The case gets reset because it's lingering. It could have just been dismissed then because it's lingering. If you're supposed to file a default and you don't do it, the court either has to dismiss the case or the court sets it for another hearing. The case is set for a hearing today. You want to rely on the idea that you believe that this was erroneously set for a hearing.
Yes.
The error was that you did not file a default. That is the error that brought us here
Your
today.
Honor, I can appreciate you saying that loudly. but to say
That's
that
the
there's
error.
one- To say that there's one error doesn't mean that there can't.
You can
be
leave
two.
my courtroom.
But
Don't talk about me saying anything loudly. The reason why I gotta say it loudly because I said it 7 times.
It doesn't
And
apply
you're
to
not-
what I'm saying.
And you want to talk about some hypotheticals that
It's
make
not
no sense.
hypothetical.
I have other people that are waiting for their case to be called timely.
Your Honor, again.
And so you
if
can
the
remove
court-
yourself from my courtroom or you can remove this case. This is over. It's been dismissed.
The court's still talking to me while I'm leaving. so-
Bye.
Take care.